Hello, testing. Okay. All right, so hello, everybody, and welcome to this STL public lecture in our STL public lecture series. My name is Norman Ho, and I'd also like to welcome those of you who are joining on Zoom. We're very privileged today to have with us my friend and colleague, Professor Stephen Gallagher from the Chinese University of Hong Kong Faculty of Law. I'm going to introduce Professor Gallagher. He is currently serving as Professor in Practice of Law, Professional Consultant, and Associate Dean for Academic and Student Affairs at the Chinese University of Hong Kong Faculty of Law. He writes in various areas, including property law, legal history, development of policy and law to protect cultural heritage, art, and antiquity, so a lot of art law related topics, and of course, law and technology. And Professor Gallagher is the author of numerous books, including The Law of Unjust Enrichment in Hong Kong, another book, Protecting Built Heritage in Hong Kong, as well as a book entitled Equity and Trusts in Hong Kong, Doctrines, Remedies, and Institutions. And of course, his most recent book, which he'll be talking to us today about, Digital Technology and Law. And Professor Gallagher will speak for approximately 30 to 40 minutes, after which we will open the floor for questions. I would like to turn the floor over now to Professor Gallagher.
Thank you very much. And thank you very much, Norman, for that very gracious introduction. Thank you to the Peking University School of Transnational Law and to Professor Norman Ho for inviting me along today. And thank you for coming along to listen to me on one of my new favorite topics, which of course is digital technology and law. So what I propose to do in hopefully about 40 minutes is go through a little bit about why this is such an important topic, why I wrote the book, and what the book covers, and possibly also saying to you what the book misses out on as well, because this is such a fast changing area that I finished this book in February and it got published quite quickly afterwards. And things have changed very quickly since then. Yes, ChatGPT was a gleam in everyone's eye back in February, and suddenly ChatGPT is a threat to everyone now, isn't it? Or it's a boon, depending on how you look at these things. As I said, thank you for coming along. Let me give you a little bit of an introduction. I can get the, so I'll talk about why I wrote the book, which was mostly to help me understand this area as much as possible, what it covers, and possibly at the end a little bit about the future for digital technology and the law. So it's been an eventful couple of weeks in the digital technology world. This is great. I started a new course. I'm teaching a new course from September, Digital Technology and Law at CUHK Law. And of course, it's great to have big scandals and ongoing trials while you're teaching a course, because of course, the students can engage a little bit more with it. And Mr. Sam Bankman-Fried has been a boon to the world in raising these issues to us about what's going on with digital technology and law. It's trying to understand what actually went on with FTX is quite difficult without having an understanding of the basic underlying digital technology. The things that went wrong are pretty basic. They're the sort of things that have gone wrong with businesses, whether or not there's criminal intent in the past. But understanding how it works with the digital technology, again, that's one of the reasons that I wanted to write a book about this. Artificial intelligence. This week, we've been told that artificial intelligence is one of Collins Dictionary's words of the year. Everyone's talking about AI. In fact, that's the word AI. I'm not sure you can have AI as a word, but they identified it as a word of the year. And of course, we've also had the Bletchley Declaration this week as well. So many of you will have seen on the news. I've got a photograph there of the back of the head of the British Prime Minister as he's talking to Mr. Elon Musk. Elon seems to be one of the driving forces here. He's been the one who's been calling for a halt in the development, a temporary halt in the development of AI for a while. You could probably question his reasoning why he actually wanted a temporary halt. Maybe he was hoping for some time for his own technology to catch up with other things that were going on. But we ended up with the Bletchley Declaration, which was signed by a number of governments in the world to identify the opportunities, risks, and the need for some global action, as it says there, on what's called frontier AI, the development of these new artificial intelligence systems as well. So an eventful couple of weeks. The past has seen lots of stories as well. These are some of the reasons that I wrote the book. We had the issues that went on with the crypto world well before. We had the issues with FTX. We had the issues that went on with cryptocurrencies. We were told at one point that cryptocurrencies would remove all the issues we had with traditional currencies, with traditional banking systems. Decentralization using blockchain would lead to a sort of a more democratic banking system that everyone would have access to. And cryptocurrencies would solve so many problems. And then we saw the volatility in the cryptocurrency markets, and we saw the crashes of certain tokens, even those that were linked into what were supposed to be stabilizing influences, the stable coins themselves that crashed as well. We saw professors grasping and trying to understand the use of artificial intelligence, generative artificial intelligence, as it was being used to create text. And we get this quote from December of last year, a professor apparently in America saying about the issue of students perhaps cheating using ChatGPT. I feel abject terror. I'm not surprised that he felt some emotion, but abject terror really in the face of this. I don't know how it's going in Peking University. I don't know how you're working here with AI. I don't know if you're embracing it. In Hong Kong, one of the issues we've had was headlines like this have, of course, made many people raise that issue of whether we can use different methods of assessment, essays, research projects anymore to actually assess our students. And we have got a body, I think, of academics who are perhaps not understanding the limitations of the technology, who are advocating that we sort of go back to traditional in-class exams, closed book, because they don't want you using any materials that have actually been produced by ChatGPT or any of the other generative AI systems as well. So we've got that sort of being counterbalanced by those amongst my colleagues who are encouraging their students to use ChatGPT and other generative AI systems, to actually work with it, to use these generative AI systems as legal assistants, research assistants for them as well. So that's a big discussion that we've been facing as well. The book charts a number of things. It starts really when it deals with things like crypto generally, moving into the field of the non-fungible token, the NFTs, dealing with the high days of the NFTs, which included, of course, the sale of everydays, the first 5,000 days. I don't know if you remember when this non-fungible token was sold at an auction. It attracted a lot of headlines, not least because it sold purportedly for $69 million US. So at the time I was teaching my art law course, and my students were saying to me, what is an NFT? And I had to admit, I didn't know what an NFT was. So that's again one of the general reasons for me writing the book, because I had to go off and try and find out what an NFT was. And I've just been talking with Professor Ho. We were saying that when we went off, we went to the usual ways. You go to YouTube or wherever else, and you look at videos that people have produced, reputable news outlets or professors around the world. And there were real problems, because I was watching these videos and finding it was difficult to understand the videos, mostly because, of course, of the language that was used. But we saw the high days, we saw a rush of investments in non-fungible tokens. And of course, that has been followed with some noticeable downs in the market as well. So this, of course, was the news last year that Jack Dorsey's first tweet, a digital image of that first tweet, which had, of course, sold for a considerable sum during the high days of the non-fungible token market, was now on OpenSea, had been unsold at $12,600 compared to, of course, the hundreds of thousands of millions that it was worth in the past. So again, the volatility of the market had been something that we need to understand with digital technology. So why did I write the book? Well, I wrote the book because a little bit, I think, out of fear of change. I think many people have a fear of change, especially when you get to my age, you start to worry about change. And it was something that I started to realize that I needed to find out more about the technology. I was a little bit afraid of the technology. And as I started to find out more, and I started to give CPD seminars for lawyers. I started to talk to lawyers in practice, and I'd talk about some of the basics or whatever. I found that a lot of those lawyers, particularly those who were as old as me, were quite worried about the technology. They wanted to find out about it. Some of them were saying, well, we'll find out about it. We don't want to be involved in that technology, but we need to find out about it. And that fear made me think a little bit more about lawyers and the problems with finding out about this technology, and also possibly some of the problems to do with law. We have to feel that, you know, many people fear technology, but we have to remember many people fear law and lawyers as well. So we should remember that, and possibly for similar reasons. We'll come on to that very shortly. So remember, lawyers have never been that popular. So the issue was this: many technologists know little about the law, and many lawyers know little about technology. So the book isn't written just for lawyers. In fact, the book is written for people who perhaps don't know much about law and don't know much about technology. So one of my colleagues at one point described the book as quite a simple book, and I was very pleased that she said it was a simple book, because that's what the intention was. Okay, so the idea was to write a book which perhaps gave an introduction both to technology and to law as well. Today, I would stress, and I think most of the people here and perhaps most of the people online are involved in law. If you want to be successful in both technology or law, you need to know something about both today. You can't be a lawyer in the future. I don't think you can be a lawyer today without knowing about technology, okay? At least not a successful lawyer. And that goes for all areas of the law as well. The book was intended to be an introduction for technologists and lawyers in a short and hopefully easy to read format. I'm not sure that's always successful, but that was the attempt. The editorial process involved a lot of people who were not lawyers reading the book as well, deliberately. Some technologists, some who weren't lawyers or technologists as well, because I wanted some input as well. It was meant to be short. It is, I think, just over 200 pages. My boss, my dean, Professor Lutz Christian Wolff, who Norman knows very well, when I'd originally talked about this, he said, see if you can do it in under 70 pages. 200 pages was squeezing a lot in there, okay? So his idea was that you should make these things short, you should get the message across to people or whatever else. And it was a good encouragement, but I failed at that, I'm afraid. The major problem in understanding both technology and law, we have a common problem. That is the language, the jargon, you know, and that's the problem, isn't it? You know, the people you talk to are not lawyers. You find yourself using legal jargon. We like it. We like that legal language. The technologists use their jargon as well. The problem, I think, with technologists, and if anyone is a technologist in the room, you know, apologies for identifying this, but the issue is this: with this technology, the terms are new, and often the terms aren't settled. Now, in law, we like to have a definition behind a term. We find that at times the same term is being used in technology for a number of different ideas, or it's been expanded or changed at times, or the term is being adapted in some way. And we have to be a little bit wary of that as well and try to find out more about it. So just some identification of it. This was a Hong Kong project earlier this year, which of course, unfortunate timing because of the disaster that happened with those people voyaging down to the Titanic at the time. But this particular project identifies some of the problems with the jargon. So this was a project back in February that was to try and encourage investment in purchasing artifacts that have been recovered from the wreck of the Titanic. And at the time, just to show you the jargon that's used, this was the publicity. The Titanic enters Web3 waters. Artifact Labs is incredibly excited to announce a new creative project that places the legacy of the Titanic in the hands of the global public. In partnership with RMS Titanic Incorporated and VSFG, we will preserve the nearly 5,500 recovered artifacts from the ocean liner as immutable NFTs and launch the Titanic DAO. So immediately, we've got lots of terms being used there. We've got Web3, we've got NFTs, and we've got DAOs. And of course, the way they use this is as if everyone understands these things. Of course, this is targeted at particular investors who have perhaps become interested in this. But if you think about this, if you are a lawyer who's asked to advise someone who's thinking of making investments here, well, then you've got to understand those terms as well. You've got to try and understand them. There were fundamental project problems with this project anyway. Anyone who's familiar with So my other area that I like to teach is, of course, to do with art law and heritage law, and the issues to do with artifacts recovered from the Titanic. There are a number of issues to do with those, but the project didn't really sail well because, of course, of all the other issues that happened at the time. So the book considers the connection between digital technology and law in three ways. The first is how digital technology affects the practice of law, because people are using digital technology in the practice of law and have been for some considerable time. The focus at the moment is on generative AI, the large language models, the LLMs. Everyone thinks an LLM is a law degree. An LLM now is a large language model. And of course, they are extremely useful. And those of you who have had a chance to play with them, to use them, you will realize that they can be useful, but they are problematic as well. Secondly, how digital technology is affected by law, because of course, many of us, again, thinking mostly of the lawyers here, whatever area of practice you have in law today, digital technology will come into it, issues to do with digital technology. So my students who are interested in being involved in, so I teach equity and trust as well, even trust law. We've got issues to do with trusts involving crypto. And of course, if we think about the issues to do with, later on, I'll mention this, probate, family law, all of these issues, all of these areas of law are going to involve issues to do with digital technology today. Criminal law, well, we're back to FTX, aren't we? You see what's going on there. So criminals, they are not slow to adopt new ways to perpetrate their crimes, and digital technology has provided criminals with lots of opportunities to actually develop their criminal techniques as well. We also have to think about how law is affected by digital technology as well, because we've had to think, because of trying to understand digital technology and how the law works with it, we've had to think a little bit about the law and actually think about whether the law has to be changed, and even our understanding of the law as well, I think, has to be changed. That's particularly to do with the idea of property itself and thinking about these digital assets, about whether they are property. So the book is split into 5 parts and 15 chapters. The introduction is a lot to do with the terms that are used. And I try to give, hopefully, some simple and relatively easy to understand explanations about some of these terms, because I think that's one of the big problems, is understanding the language. Then we move into artificial intelligence and the law. As I said, I wrote this book, finished it just before Christmas, revised it for February. So there's not that much on generative AI. I have to say that, because at the time it hadn't been the big issue that it was to become. Then we move into digital property and digital assets. And that was something I was very interested in because, as I said, I teach a lot of property law. So for me, it was interesting to think about how we had to think about digital assets, including cryptocurrencies and non-fungible tokens, about whether they were property and how they should be approached if they were property as well. And then final sections we come into is that concept of the metaverse and linked into Web3 as well. There is a conclusion. I do put a glossary in. There's quite a big glossary because of all these different terms as well. Some of the terms in the glossary are, of course, to do with legal terms as well, because, as I said, the book isn't intended for lawyers. It's intended for non-lawyers as well. The starting point then was to do with artificial intelligence and the law. And one of the points I wanted to make is, I think particularly people of my generation, maybe younger people as well, are quite worried about artificial intelligence. There is a fear about it. So to explain why, I blame science fiction. Okay, science fiction is the issue. I'm not sure if anyone is as old as me or can remember this particular film, but this is still, of course, from 2001, A Space Odyssey. I don't want to blame Arthur C. Clarke because, of course, he was a great foresight to do with technology in many ways. But that idea of the thinking machine has worried people for a long time. And it has led to the production of many stories, many sort of science fiction horror stories to do with killer robots, super intelligence taking over the world, eradicating humankind or whatever else. And I'm sure that is in the back of a lot of people's minds. And again, those who've been trying to restrict the use of AI recently have played on this as well. Yes, Elon Musk has been very keen to sort of talk about the worries about super intelligence and the use of this to do linked into weapon systems and everything else as well. It is true. We see quote's been put forward from Einstein as well. I fear the day that technology will surpass our human interaction, the world will have a generation of idiots. The idea that actually, you know, if we're going to rely on the technology, it will affect the intelligence of human beings. Again, I think that's problematic. In the book, I try and address that a little bit because for me, AI is always going to be an assistant, or it should be used as an assistant. So I think that humans, in many ways, it will draw us on. It will hopefully make us more intelligent to interact with this in many ways. And by the way, we should always remember that that actually, I think, is a generated quote. I think it's fake news anyway. So Einstein never said that. So, but this is one of the problems we've got, isn't it, with the technology today? We have to be very wary of all these things and taking things. I showed that slide to one of my students at one point in a group of students. One of the students said, "That's fake news. We found this out." So, you know, that's what we have to be careful. That is one of the issues. The general thing I think was this, though, when I looked at the practice of law using AI, and there is, I look generally at legal tech, what's being used. There's already a lot of use of AI in the practice of law. We're all using AI every day, okay? If we use predictive text, if we use, if we've got a Word document where we've got a grammar check or a spell check or whatever else, these are forms of artificial intelligence. And no one's really scared about spell checker, are they? No one's worried about this. So we've all been using this. But when I started to think about the practice of law, again, when I was talking to lawyers in Hong Kong, a number of them were worried about this. They were worried about actually using this technology. But when we start thinking about the things that are already being used, the e-due diligence, the e-discovery systems that people are using, it's made the job of being a lawyer a lot easier at times, more efficient. There is a concern. The world hates change. You know, we've got that sort of quote there. But, you know, we have to remember that lawyers don't always hate change. Actually, lawyers have often been amongst the first to embrace change. If we went to think about the office workspace, lawyers have been the first to bring in labor-saving devices. If we want to think about first offices to have telephones and first offices to have typewriters, if anyone knows what a typewriter is, and, you know, PCs and all of these different things that came in. Lawyers were the first to use these often. Why? Because it saves money, because it saves time. It's more efficient. And those are the things that lawyers have always been looking for. So they generally embrace technology, cost savings, quality, and also for opportunities as well. Because lawyers are also always looking, you know, to be the lawyer that people go to. So you need opportunities. You need to make yourself special in some way. So embracing technology has always been something that lawyers do. And again, I know there are LinkedIn concerns. I'll mention a little bit later on about this, but I should raise it now. Amongst our students, amongst the students I teach and the students I've been talking to, and even amongst practitioners, there's been a concern that, of course, there will be consequent job losses, that there won't be so many places for trainees. And in recent years, we have seen a little reduction, but that could be more to do with the global market trends than anything else. The idea of technology reducing the number of jobs, it doesn't always work that way. In fact, in human history, when we've seen technology come in, what usually happens is we change jobs. Jobs change. The way we work change. And I think for the legal workspace, that's definitely the thing to think about. Trainee lawyers may not have to do as much of the boring stuff that they used to have to do. The checking of documents, the looking for spellings, typos, whatever else. Maybe that's not going to be the thing they do. So again, embracing the technology early on is something that I think all people who are looking to become lawyers should be thinking of doing. That's been the question. Is it the end of lawyers? Some of you will have read Professor Susskind's book, The End of Lawyers, which was published a number of years ago. I think Professor Susskind is very happy that we had all the issues, the changes that went on in the last 3 or 4 years to do with the practice of law, because those are the things he predicted many years ago. If you've read the book, you'll know that actually his book ends by saying it's not the end. Technology is not the end of lawyers. It will just change the way that we act as lawyers, that we work as lawyers. And I think that's, again, something that we have to remember. When I move on, talking about artificial intelligence generally with the law, of course, there are so many things to think about. Fintech, autonomous vehicles and weapons, robots, and they bring the issues of control over them, the risks to do with them, disputes, potential liability. Hopefully, as future lawyers, you're thinking, wow, that's lots of work, isn't it? And that's the thing I think you've got to think about as well, that this technology will bring more opportunities for people who understand how the technology works and some of the problems to do with it as well. That was the issue, though. People have been thinking about as a threat to jobs. As I said, for lawyers, I'm not sure about this. For my own interest in things to do with art, it's brought in some interesting ideas. Artificial intelligence producing art raises a number of interesting questions. This is the portrait of Edmund de Bellamy. This is the first artwork produced by artificial intelligence, by an algorithm, which was sold at an auction. It's not the first ever, but it was the first one that was printed out and sold at an auction. Estimated at a few $1,000s. Of course, it made hundreds of thousands of dollars when it was sold. Why? Because it was the first one. It's not a great artwork, is it? I don't think anyone would be keen to hang that on their window, but it raises many issues immediately, doesn't it? This artwork was generated by AI, which was trained on very traditional portraits that were about 100, 150, 200 years old. Why? Because they're intellectual property issues. So we've got intellectual property issues to do with the training of AI. We've got issues to do with who owns these assets that are created by AI as well. And those are all things which I try to cover in the book as well. Then we move into digital property and digital assets. As I said, this is a particular interest to me. Many of you will know that for many years, we have been trying to consider the nature of digital assets. And by that, I mean many things that you've got in the room with you today. So many of you on your phones, on your laptops, you will have your photographs, you will have your music collections, you will have your documents that you've created as well. Digital assets, that general sort of idea. And an issue has arisen about the ownership of them. So hopefully you're all familiar with this great actor, Bruce Willis. And if you haven't seen any of his Die Hard films, great films. I'm not sure they really come into the art world, but he had an issue to do with, or it was reported he had an issue to do with his music collection, because he had an iTunes collection, which was substantial. It had been estimated he'd spent somewhere between $250,000 and $500,000 US on a collection of music. He was a great music fan. He actually produced a couple of records as well in the past. But the issue arose, it seems, when he thought about passing on his music collection to his children. And again, for lawyers, you know, this is something that your clients will be thinking about at times, passing on of their property as well. So he's got a music collection, he owns it, he wants to pass it on to his children. Does Apple say he can? Because it's not really his property, is it? He's got a contract with Apple. He's got a license for that. It's a personal license. It becomes a real issue. So again, in the book, we have to start thinking about this. When we move into blockchain, a particular type of property issue arises there. So we have to think about how blockchains are created. So I try and explain that. How the blockchain works in a decentralized method as well. So I try and explain a little bit about that. And then, of course, we talk about what blockchain creates. It creates fungible tokens. So we have to think about what fungible tokens are. They exist in the real world. So if you've got some cash on you, and I know Shenzhen, I'm told not much cash is being used anymore, but in Hong Kong, we are still old-fashioned. We have a cash in our pockets. If you've got your $10 note, this is a fungible token. It's created with the intention that it should be interchangeable. And of course, that's our cryptocurrencies. These are tokens. These are something created to represent something else, but created on a blockchain, on that decentralized ledger technology, but intended to always be interchangeable. So we have to think about the different types of tokens. We have to explain how they're created and some of the problems that arise, the benefits of fungible tokens, and particularly in the crypto world, and of course, some of the issues that arise as well. Then we have to think about non-fungible tokens. I thought this was a great illustration of a non-fungible token. So this is an ancient Chinese vase, which is inscribed with the record of a gift to an official. So this is a record of a particular transaction. That's a non-fungible token. Yeah, this is a record of a transaction which is not intended to be interchangeable. It is a unique transaction. So a record of a unique transaction would be a non-fungible token. I chose a sort of more familiar idea to sort of represent this in the book as well. This is a ticket. It is a ticket for a Champions League final. It is one of the best ever Champions League finals because that was the one Chelsea beat Manchester City, and I'm a Chelsea fan, so it's big for me. Great night last night, beating Tottenham as well. But this ticket is, again, a great example of what a non-fungible token is. Try to understand a non-fungible token in the digital world. It's good to remember we have them in the real world as well. So a non-fungible token here, it represents a right. It represents a right to attend that particular stadium on that particular night, to watch that particular game of football and sit in a particular seat. It is not interchangeable with any other seat. You haven't got a right to sit in any other seat. You haven't got any right to see any other game of football or go on another different night or whatever else. So it's evidence is a unique right. And again, once it's been used, it's still a non-fungible token because it now records that particular transaction and that right as well. So a non-fungible token is just a record of a right, even if the right has been executed as well. In the digital world, non-fungible tokens become things like this. Records of digital artworks, which are, again, meant to be unique. So even if we've got a digital artwork, which is reproduced many, many times, if we record it on a blockchain as a unique record, then it does become a unique work. And that's the way these things are being used in the digital world. The next chapter looks at smart contracts and decentralized autonomous organizations. And I must admit, I spent a bit of time talking about DAOs because they really did interest me. The decentralized autonomous organization, here I've given the example of the Constitution DAO, which of course is one of those ideas again where you see the digital world going wrong. So Constitution DAO, a decentralized autonomous organization, is a grouping together of people for a business purpose, usually, so far in the digital world. They exist on blockchains. And what happens is you advertise the fact that you are creating this particular DAO, usually for a particular business purpose, although you can create it with a general purpose. And then you encourage people to buy tokens, tokens that you create on that blockchain. And when they buy those tokens, they don't just get the token, which is, of course, a share in whatever project you are carrying out, but they also get rights to vote, usually, in that particular project and direct the way the project is. Now, the Constitution DAO announced that there was a copy of the US Constitution coming up for sale. Now, this is an extremely rare and extremely important document in world history, not just in American history, in world history, of course. And everyone knows it's going to make many millions of dollars. The Constitution DAO raised $46 million worth of Ethereum cryptocurrency. They said, we're going to buy this, and then we're going to commercially exploit it. They haven't really worked out why. They said, if you buy a token, you can vote in how we're going to commercially exploit this. Perhaps we'll create a non-fungible token. Perhaps we'll fractionalize the ownership of this in some way. Anyway, it meant 46 million meant that with the extras that you get in auctions, they could bid up to $40 million for this. When they went to bid at the auction, unfortunately, they were outbid by an American billionaire. And of course, that raised lots of issues because immediately afterwards, everyone said, okay, what happens to the money now? And of course, the DAO hadn't really thought about what would happen if they didn't buy the Constitution. They just assumed they would buy the Constitution. So I think it showed a bit of a naivety in the business purpose. And then it raised all the issues about, well, actually, how is that money owned now? Who owns it? Because the DAO wasn't represented by a registered company. It hadn't got a corporate existence. So people had to try and think about how DAOs actually exist. These are groupings together of people for a common business purpose. They are linked perhaps by an agreement amongst themselves, but in many effects, the only ways I can think about them in the common law system would be an unincorporated association. And there are benefits at times for using unincorporated associations, but there are lots of drawbacks, which of course is why most jurisdictions created corporate structures. So again, it raises issues of the legal status of the DAO, the business purposes, management and control, liabilities of members and managers, and also this idea of fractionalizing ownership. These sort of joint commercial ventures raise issues of securities regulation as well. And there are ongoing cases around the world, including in America again, about this idea of, are these investments actually securities and should they be regulated activities? The next chapter talks generally about issues to do with crypto assets and the law. And again, this idea of ownership, again, the property side of me always wants to think about this. How do you actually own these particular assets? So I brought a number of things in there. In chapter 12, I try and cover all the issues to do with civil liability to do with these and all of those involved. And there are so many actors in the digital world that we have to start thinking about these problems. Again, FTX, in Hong Kong, we've got the JPEX ongoing scandal as well. They've raised these issues. It's not just the criminal side. That's the next chapter, talks about the criminal side, but it's the civil side. When people lose their money in these investments, they want to know, can we get it back from anyone? That's the big issue. So there are all these issues. You know, lots of these assets have disappeared. The idea of crypto in particular was that it was going to be a secure investment, that it would be a secure record, that you would never be able to lose your crypto. And we've already had lots of people losing their crypto, whether by their own loss of their digital wallet keys or issues to do with people dying and not passing on them. So we've had issues to do with probate as well. Lawyers who are involved in the probate world are already having to try and think about advising their clients when they're writing wills about how they actually pass on information about their crypto as well. Divorce and tax, many issues to do with that. So I try and deal with those in sections as well, particularly, of course, because the crypto world, it's very good at hiding things. Yeah? Crypto, the whole idea of being hidden, well then, again, if you want to hide assets, if you are trying to deliberately avoid passing things on to your wife or to the tax man, well then crypto world has opportunities as well. The whole concept of recovery, we've seen many cases ongoing around the world, and I detail some of these, where people have tried to identify the digital assets, in particular crypto, again, as being property. Why? Because they want to assert some sort of proprietary interest, launch proprietary actions, use proprietary remedies, injunctions, and other things. So we have to think again about the nature of crypto and other digital assets. And it often depends on the particular way that the crypto has been developed to actually then think about whether we can use these existing legal remedies. And going back again to the whole idea about whether digital assets, in particular crypto, are property, whether we need a new category of property, whether the law needs to develop to identify a new category of property for these digital assets, perhaps a digital objects category as well. The whole idea of suing people, do we see the promoters, sue the promoters of projects, celebrity endorsers? At the moment in Hong Kong, a number of celebrity endorsers have already been arrested to do with the recent JPEX scandal and have had things that they were given by JPEX taken away from them at the moment. We don't know whether these will be finally used to deal with some of the liabilities of the JPEX operation, but perhaps. Again, the securities issue is also something that needs to be considered, and I try to consider it in that particular chapter. Thinking about infringements of people's rights, again, issues to do with intellectual property. That comes in a lot with the digital art world, with the unauthorized and unlicensed tokenization of digital art. So this particular digital artwork was produced by one digital artist who then discovered that it was being offered for sale as a non-fungible token on one of the big platforms. He had never given any permission for it to be so used. It had all the details of him, the artist on it, or whatever else. And of course, the nature of digital art makes it very easy for people to take copies, to create tokens of them, and to, of course, sell them on. So there are lots of issues as well. Other issues that have affected the art world, and again, this is my particular interest, is the encouragement that's been made by some people who are involved in the digitization of art, the creation of these tokens, to actually destroy real world art. So this was only a print, but it was a print of one of Banks's most popular works, which is Morons, which is, of course, an artwork which pokes fun at the whole of the art world and the stupidity of those who invest in art in many ways. And of course, this was bought by a particular group who then filmed themselves setting fire to it, turned that digital recording into a non-fungible token and sold that for $380,000 US. But there have been other projects as well which have encouraged the destruction of real world art, which raises a number of issues. We then get into digital assets and criminal liability. And again, as I said, one of the assertions of those involved, in particular in the crypto world, has been the security that you have with your crypto assets. The fact that your ownership is recorded on a block on the blockchain, and that can't be changed. This idea that there was no change in these particular records meant that, of course, you were secure in your ownership of any property. And then we see stories like this, people saying, hey, my account's been hacked and my digital assets have been transferred. What usually happens is the hacker takes control of your digital wallet. He then sells your your crypto to himself using another sort of pseudonymous wallet, has it transfer of ownership to that wallet, and then of course he then puts it on the open market and sells it, usually for less than the market value, so it sells quickly. That means that the original owner now has lost their record of ownership of that particular crypto asset. We know where the crypto asset is. It's still on the same place on the blockchain where it was originally created, but we now have a new record of it being owned by someone else, a bona fide purchaser. And of course, in this particular circumstance, the original owner said, look, I know where it is. I know who's now got this. I know that it was transferred by those who didn't have the right to transfer it. I just want my NFTs back, the record of my ownership of them, because the NFT stays on the same block on the blockchain. I want the record of my ownership back. And Nifty Gateway in this particular case said, well, we can't, because of course that's part of our terms and conditions. The idea is that, you know, if you lose control of the assets, we protect those who purchase, we protect the bona fide purchaser. Your recourse is to try and find the people who've actually interfered with your asset or whatever else. And again, your other recourse would be to try and sue Nifty Gateway. I don't know if anyone's looked at the terms and conditions of Nifty Gateway. I was looking at them with my students the other day. They have just got layer upon layer of contractual restrictions on attempts to actually bring any action against them. Other crimes have involved fraudulent investment schemes. Again, I would say these are very traditional in the way they operate. The difference is that they've used the new technology for them. So this was an investment in South Korea a few years ago, which attracted a lot of attention when it was announced that a particular conglomerate had identified the resting place of a Russian warship that had been sunk back in the early part of the 20th century. They claimed that on board was 132 billion US dollars worth of gold. And they said, it's going to cost a lot of money to actually salvage this. So what we're going to do is we're going to issue a token. And if you buy a token, we'll use that money to then salvage, and you will get a proportionate share any salvage we make. Shipwreck scams are common. So if anyone ever asks you to invest in recovering stuff from shipwrecks, be very careful anyway. It's a common scam, but using a non-fungible token, using cryptos as well to come in here, that was a novel idea. Anyway, within a week, the CEO of the company was arrested, but I think people lost about 12, 14 million US dollars in the investments, and most of that hasn't been recovered as well. Major problems with the whole idea of recovering treasure from ships, particularly when it's a Russian warship. I can't see Mr. Putin giving up $132 billion worth of gold without a fight in many ways. We're coming towards the end. I had to consider the whole concept of the metaverse. And the idea of the metaverse is something which is still developing. It also has to be considered alongside the concept of Web 3, Web 3.0. We are meant to be moving into that idea of Web 3.0, but again, the whole idea of Web 3.0 is being developed, as is that concept of the metaverse. In considering the metaverse, we have to think about what the law will be if we do ever achieve the metaverse. We've already got various virtual realities. We're already using augmented realities as well. And already we see legal problems with these. We need to think about this. Virtual worlds, do they have virtual laws? Can you sue in the real world for harm and loss in the metaverse? What happens if you are harmed in the real world because of something that happens in the virtual world? How do the laws interact? Can we have limitation of any recoveries or any actions in the real world by, of course, the laws that exist in the virtual world? So those are the sorts of things I try to talk about a little bit at the end of the book. And again, even simple things like we've had lots of cases to do with intellectual property infringements, to do with products being sold, created and sold in the metaverse, in virtual realities as well. Again, lots of uses of augmented reality have again attracted attention legally. And if we're thinking about things like the Internet of Things, which again links into the whole 3.0 and even metaverse idea, that raises lots of legal questions. So if you've ever been tempted to buy one of these dolls, you may remember the story about this. This was a few years ago. This went a bit viral, the story, because in Germany, these dolls have been banned because these dolls are linked to the internet. And they don't just download things from the internet, they actually send things to the internet as well. So, of course, there were major issues that they were used to record. They have cameras in them and other things as well. And of course, there was the idea that these things could be hijacked. So again, the end is all about this idea of all these things that we now use that are linked together. We have to start thinking about what access we're actually giving of our real world lives to those who actually populate the internet as well. For the conclusion, well, it deals with a few of the more later stories. Again, the crashes in NFTs, the issues to do with the volatility of cryptocurrencies as well. And I try to talk a little bit about what I thought back in February, the future for technology and law would be. I did think mainly that technology offers lawyers a lot of opportunity, particularly future lawyers. I think that if you've got the chance and you can study something to do with digital technology linked into law, then you should definitely take that opportunity. And I know that Norman said that I think you have got courses here, so I would encourage you to take courses in digital technology and law. A lot of people are talking about AI and law at the moment, and a lot of people are asking that question, will artificial intelligence replace lawyers? And most people are pretty clear, artificial intelligence is not going to replace lawyers, okay? What will happen, I think, is that we will get, some people are saying, lawyers who don't use artificial intelligence will be replaced by lawyers who do use artificial intelligence. Well, I think it's more than that, because I think all lawyers are going to be using artificial intelligence in some way. So I think the answer, what will happen in the future, lawyers who use artificial intelligence well will replace lawyers who use artificial intelligence not very well. So the better you know, the more you know about the technology, I think the better lawyers you will be in the future. Thank you very much.